ndị bike ụbọchị nketa mara na anyị na mma anyị si ka nkonye chiri ya zerụkwa dịka o si dị ya bụ Easter dis 24 ka anyị si na-ewetara ya bụ ozi gbasịta maka ya bụ ife na-ada na-akpọtụ n'obodo nọ n'ime ya n'ụbọchị nketa wetara nnukwu ozi ọ ya amasị m na ya tọrọ ntị n'ala gee ya bụ ife anyị ji maka ya wee bịa n'ụbọchị nketa n'iru akwụkwọ update anyị ji maka ya bụ according to the Biafran activist wetara ya bụ ozi as a quote. Breaking news: Maazị NNAMDI Kanu's trial to resume. Justice Omotosho breaks the law. Hear the news in details. According to the Biafran activist wetara ya bụ ozi n'iru akwụkwọ ọ ya amasị m ka ge ya bụ his own point of view na this update o wete dịka ihe ge ya bụ ife kabarụ kiri ya tia n'ife niile okwu n'iru akwụkwọ gbasịta maka ya bụ ife nke okwu gasị. Over to you, sir.
Omotosho is expected to reconvene a court session and give judgment on Maazị NNAMDI Kanu's case because under the constitution, excessive adjournment is illegal under section 36 and goes against the spirit of fair hearing and can also be seen as a witch hunt. The judge also can be petitioned and the case file be transferred to another judge and the case withdrawn totally from his hands, and of course he can also face certain sanctions. And of course in this case it's even an accelerated trial, and that trial is supposed to be running day to day until the judgment has been found. But in this case it is not so. Rather, NNAMDI Kanu is even suffering exactly the same way he suffered during Justice Binta Nyako. Let me read something quickly for you to guide you in all this. Now, listen very carefully while I read this for you. If you are watching, go and finish up. If you are eating, please finish up or leave it and watch this video because it's going to be very educative, and I want you to pay attention on the reasons why Omotosho is going to convene a court session and actually give judgment on this case before this thing goes beyond the level it already is. Excessive adjournments are against Nigerian law. Listen, especially when they violate a person's rights to fair hearing and trial within a reasonable time, as enshrined in the 1999 Constitution of Nigeria as amended. According to Section 36, Section 1 and 4 of the Constitution, 36 Section 1 says, in the determination of his civil rights and obligations, including any questions or determination by or against any government or authority, listen, a person shall be entitled to a fair hearing within a reasonable time by a court or other tribunal. Did you hear that? Did you hear that? A person shall be entitled to what? Fair hearing. Fair hearing. That means a fair hearing is a hearing that does not violate a person's rights, that does not seek to intimidate a person or subject a person to imprisonment for a long time just because the person is facing trial in the court. So the Nigerian Constitution guards against prolonged detention. This is exactly what NNAMDI Kanu fought against under Justice Binta Nyako, and he got a judgment from the National Judiciary Committee, from the NJC, that sent a letter and took away the case from Justice Binta Nyako because of this same thing. And of course, this is exactly where Omotosho is still heading to. As an accelerated trial, this case is not supposed to last more than 1 month because in our constitution, accelerated trial is also stated there that it's supposed to be a day-to-day. I'll read it for you. A day-to-day activity until judgment is found. And in fact, according to the ACGA, it stated clearly that the adjournment should not be more than 14 days. Should not be more than 14 days, except where stated clearly for obvious reasons. So this NNAMDI Kanu's case and what he's passing through goes against totally the spirit of Nigerian law and the letters of it. It is illegal that NNAMDI Kanu should be passing through this 3 months trial and now 4 months adjournment in total by August 10th and on March 21st that this whole case started. Let's go on. Section 36, Section 4 says, whenever any person is charged with a criminal offense, he shall be entitled to a fair hearing in public within a reasonable time by a court. What does it mean? A fair hearing and reasonable time are fundamental rights. The Constitution prohibits prolonged, indefinite, or arbitrary adjournments. It is there in Nigerian law. It is there, and of course, it's already started happening to KANU. And Omotosho doesn't take time. This case is going to be removed from his hand, and of course, he may even face tribunal for it. That means, the way I see it, Nnamdi Kanu's lawyers should quickly as possible press for the case to be reconvened immediately, so that Omotosho can give judgment immediately, because the court has been adjourned for too long. Listen carefully what Constitution says. A court that keeps delaying a case violates the accused's constitutional rights, especially in criminal trials where liberty is at stake. Did you hear that? So Omotosho, going by all this, is expected to reconvene the trial immediately and give judgment. October 10th should not hold, will not hold, the way I'm seeing it, because of course the lawyers are already on top of their toes, and as I'm talking to you now, it is obvious that they are going to start acting upon this, because nothing stops Omotosho from repeating the same thing on the 10th, because they start playing this game. I'm calling upon international bodies right now to take note that Omotosho is expected, as immediate effect, to reconvene the court session immediately and give judgment. Let me show you something. Listen to me. Accelerated trial refers to court proceedings that is deliberately fast-tracked in order to conclude much quicker than regular trials. An accelerated trial is a judicial mechanism aimed at avoiding delays, adjournments, or unnecessary technicalities, ensuring justice is not denied through prolonged detention or stalled legal process, often used to high-profile, sensitive, or time-bound cases. Also, backed by provisions in many legal systems, Section 396, Section 3 of Nigeria's Administration of Criminal Justice Act 2015, which says that once a trial has started, it should proceed day to day without unnecessarily delay. Day to day. Day to day. Which is what he was actually doing before when this case started. Along the line, he started playing that game, giving 2, 4, 5 days, 1 week, 3 weeks, then 1 month adjournment, now 3 months adjournment. Listen, let me carry you on. Accelerated trial is a system that promises to treat the case as urgent and serious, uphold the dignity of justice, prevent justice from becoming a punishment. That is exactly. So like I said earlier, the ACGA was enacted to speed up criminal trials and prevent unnecessarily delays, which is the Administration of Criminal Justice Act, ACGA 2015. That was why it was set up, to speed up trials and make it more of accelerated. Now, it says, where a day-to-day trial is impracticable, adjournment shall not exceed 14 working days at any particular time. Please tell me, going by this law now, is Omotosho, what he's doing, is it legal or illegal? Judge it yourself. These adjournments now he's giving, is it legal or is it illegal? You know, most of these politicians who sometimes, are working alongside these judges, telling them what to do sometimes, they don't know the law. And they tell you do this thing, and you say, Oga, it's illegal, and they force you, or they talk sense into you, or whatever it is you people discuss. End of the day, you start breaking the law because of power. So in the presence of power and politics, there is no law. But that is exactly what we are saying. You can't continue like this in a country. You can't. And say that people should remain in that country. Now it says here that a trial shall be concluded within 180 days concluded from date of arraignment, which means that by this law, Nnamdi Kanu's case should not exceed July. See, March, April, May, June, July, August. Okay, August. Nnamdi's case should not, never, no matter what, exceed August if they ever want to adjourn for reasons best known to them. That means if this case crosses August, then, which is already almost reaching, that means they are now is a breach of the Constitution of Federal Republic of Nigeria, which says that a criminal case under accelerated trial should not exceed 160 days. See, I'm not telling you what I know. Go and read the Constitution of Nigeria. It is there. Section 396, subsection 4 to 6. Go and read it, of the ACGA Act. Administration of Criminal Justice Act. It is there. It's not me saying. It is their law. And they are breaking the law. And in punishing this man more and more while breaking the law. Now, who is going to hold them accountable? There are laws. There are laws and they dodge it. That's why I'm calling Nnamdi Kanu's lawyers, KANU Agabianko, use this law and file a petition immediately. Because KANU spending 3 months there is not good for the justice system that Nigeria has sworn to protect. He needs to go free. He needs to go. Let's go on. Adjournments shall be limited in number of duration. So, judges are legally, listen, required to avoid long or frequent adjournments. 14 working days is the maximum allowed for each adjournment, unless extreme circumstances apply. Is Omotosho going to come and tell us the extreme circumstance that applied here now? That's why I said that this Buhari's death, was actually maybe the circumstance they used to postpone. But actually, what concerns Buhari's death with Nnamdi Kanu's case, I know very well for sure that was why it was adjourned at that moment in time. It was political. I will say it any day. And that would have been the reason why. When they say extreme circumstances, what does it mean? Does it mean now that the whole country should stand still because of somebody is dead? Does it also mean that the whole country should just, close down because Buhari died? Is that the extreme circumstance that came up that made you to adjourn it for such a time? I know that is the reason. But it's so shameful because you cannot say it. And that is illegal because it does not have anything to do with the judiciary. It has nothing to do with Nnamdi Kanu or the defense or the judge. And these are the only circumstances that you can now appeal to the NJC and tell the NJC that, look, this case, I may have to adjourn it for this longer period, and they will have to approve it. Because I know any further extension from the 14 days should be approved by the NJC. Should be. So when excessive adjournments become illegal, adjournments become illegal, unconstitutional, when they are frequent and unjustified, when they exceed legal time limits under ACGA or relevant court rules, when they are used to punish, delay, or weaken the accused, when they are based on absence or laziness of prosecution or judge, which happened under, Bintanyako, when they violate an accused's rights to liberty, especially in cases where bail have been denied, and there are consequences of illegal adjournment. Let me show you. Violation of Constitutional Rights Section 46 allows victims to sue. Yes. Any breach of your fair hearing rights in Section 36 of Nigeria Constitution, you can sue to protect your rights for excessive adjournment, which is looked and seen or deemed as a punishment. Because the way Nnamdi Kanu's case is being adjourned so far now, it looks like a punishment. It wants to look like what happened to Bintanyako during her time. That's how it looks like now. Also, the consequences are you can petition the National Judicial Council, NJC, against the judge. You can petition Omotosho. If he fails to reconvene this case and proceed with his job, petition him. Yes, because it's already a week. This weekend now, make it 2 weeks of that adjournment. This week, Friday coming. Make it 2 weeks. That is the maximum he can be given to to adjourn a case at every interval. 2 weeks, not more than that, 14 days. It's in the constitution, it's there. Also, the consequences can be grounds for appeal or dismissal of charges due to abuse of process. Nnamdi Kanu's lawyers can appeal to dismiss the case because of abuse of process, which comes under technicality in court. And of course, we have seen cases where Nigeria judges and courts give cases, people win cases because of technicality. So what stops Kanu from winning this case? Under technicality. He went to the first court, it happened. Now he's in Omotosho's court, it's already happening. It's already happening, and nobody's talking. I expected the lawyers to raise alarm once this case was adjourned for more than expected time. To October 10th. The first one was 1 month. You cannot give me any excuse. That first 1 month that was adjourned was even too much. So KANU's multiple adjournments, especially without progressing with the trial or giving a bail to him so far, raises serious constitutional concerns. Being held without timely trial is unlawful detention, and his lawyers can invoke Section 33 of the Constitution, Article 7 of the African Charter on Human and People's Rights, and Section 396 to 398 of the ACGA to challenge these delays. That is why I say Omotosho, bearing any unforeseen circumstances, is going to reconvene this court case and give judgment immediately and end the suffering of this young man to go back to his family. He has done nothing that is worth stressing him this way. In fact, he has even served the punishment for whatever they said he committed, and the insults they said insulted people. He has served prison cell for 6 years for it. So be it. Let him go, release him, let him go. So yes, accelerated trial is clearly backed by law. So they know the law, but they don't want to do it. The law is clear. You cannot carry out accelerated trial and start adjourning case indefinitely, monthly, 2 monthly, 1 monthly. It's not done that way anywhere. You can see I've quoted the exact laws, and it is clear for all to see that Nnamdi Kanu is passing through a witch hunt. It is no more a trial. These are people who just sit in their rooms and discuss what will happen to his future. His life is being discussed in beer parlor, in big mansions, everywhere, in government house. His life is being discussed by people. I don't think his life is discussed in the court again. It's no more in the hands of the judge. That's what I'm saying. Omotosho needs to reconvene this court session now, because by Friday or Saturday, it's going to be 2 weeks. 2 weeks that the case was adjourned, or even more. And that is the maximum time given for any trial to be, for any adjournment to be given, not this one we are seeing. So that is what we are saying. It goes against the spirit of fair hearing. That is exactly stated in Section 36. And it can also be seen as a witch hunt to tie him down in the cell for long. Somebody you said that you did not like the way he was in cell for years, all of a sudden you are the same person that's adjourning a case for 3-4 months. You are the same one. What went wrong? What went wrong? Of course, it doesn't matter what went wrong. Please, this is illegal, and this must be called out for what it is. It is an illegal act that is not backed by law. Keeping Nnamdi Kanu for long like this during this court trial is not backed by any law in Nigeria. I have not seen any law that backs it, that says you can keep a man indefinitely in trial. You can keep a man in cell facing criminal charge indefinitely. It is not happening. Such a case like Nnamdi Kanu, who is a high-profile case, should have been treated respectfully. Respectfully. He has faced this under Nyako for 10 years. Now he has come for 7 months now. There is no headway in this case, because the way it is, nobody knows the mind and the plans of people who are deliberately doing this to him. So what I'm saying is, Nnamdi Kanu's lawyers, please, you people are too silent. You are too silent for this. Please, pursue this thing well. Don't play games with them. Don't be too calm or feel we are looking for this, we are looking for that. We want to... What is it? They want people to be kept like this so they can have their way. That's what they are doing. And it's obviously looking like that. Please, stand up to your job and call Omotosho back to the court. Let him give judgment to this case. Let's go. It's over. It's over. Injustice is injustice anyway in the world. Please, let it end. Call the court session now. Summon the court session now and end this case. Supporters family worldwide, we are a family of truth, a family of purpose, and a family of faith. And you know, with faith, we can move all mountains. We are not afraid. Watching me from everywhere around the world, from the US, from Europe, to Asia, to the Pacific Islands, to Australia, to Africa, North and South, to everywhere, to the Indian Ocean and Antarctica, everywhere, I respect you. Thank you for always tuning into my video. Don't forget to turn on notification and click on the bell that says all, select all to get notified whenever we drop a video. I have been your host, Chi Ne Du. Thank you for watching my video. So I'll see you next one. Peace.
Ebuma na-ege ntị edalụli na enukwu si wee na n'onu m ụbọchị nke taa na Eastern News 24 bụ ebe anyị si were wetara ya bụ nnukwu ozi gbasịta maka ya bụ ife na-emenụ ka efi were ikwu gbasịta maka ya bụ ife ndị anyị wetara n'ụbọchị nke taa n'iru akwụkwọ.